Hello, everyone, and welcome to Reject Modernity, Embrace Tradition, the show where, as always, we take you back to the good old days, just probably not exactly how you would expect from our title. I am Clayton Becker.
And I am Megan Cox.
And before we get into our content today, we just want to give a brief forewarning to everyone who waits on these with bated breath that there won't be an episode next week. I am attending the Western Political Science Association conference in Seattle, and we just figured it was too much work to try to get me to record from my sister's apartment in Capitol Hill, rather than just taking a week off. So don't worry, we'll be back the following week, but we'll be taking a 1-week break so that I can go and do my actual academic job for once. Let's get into what we're actually going to talk about today. So, Megan, what is it that we're actually going to talk about today?
We are going to be talking about abortion rights. Isn't that fun?
So much fun. And specifically, we're going to be rejecting Dobbs, the Dobbs decision, Supreme Court case Dobbs versus Whole Woman's Health, and we're going to be embracing abortion rights generally. We're not embracing Roe specifically, and you'll see why when we get into it. But yeah, the long story short is that the Dobbs decision was bad in a lot of ways, and it's caused a lot of consequences, and quite frankly, it deserves to be rejected, even though it is only 2 years old. Normally, we reject things that have been happening for a substantially longer period of time on this show. But we figured it was time to talk about abortion rights, the happy, fun topic that it is.
Yeah. Yeah, I mean, in the sense that this has been coming for a very long time, and we're going to talk about how that is. This has been in the works for about as long as many of the bad social trends or legal trends that we talk about. Almost as soon as it happened, Roe was going to be on the chopping block at some point if somebody could figure out how to do it. So I think what we're going to do today is, in a shakeup from our usual format, Clayton, we are going to talk about the legal regime and how we got here. And we're going to talk about some legal changes that we recommend embracing. And then in the back half, we are going to talk about policy and how the policy of restricting abortion has bad outcomes. And then we're going to talk about policy changes. Is that a good summary of what we're about to do here?
Yeah, normally we would go through the first half of just everything that's wrong, and then we'd give you some policy recommendations in the back half. But since the policy recommendations on this one ultimately boil down to leave people the fuck alone, sort of, we're gonna do a little bit more of splitting it up between the legal and policy consequences, legal and policy regimes here, just to make it feel a little bit more thematically consistent, since otherwise we'd have 45 minutes of telling you what's wrong, and then 5 minutes of Megan and I ranting about leave everyone the fuck alone. So without further ado then, let's get into the legal frameworks here. How did we come to this? How did we come to Roe in the first place? What's the whole legal history?
Legal history, when we say we're taking you back to the good old days, today the good old days are the late 1700s. There's actually probably one of the best parts of the Roe decision is the summary of the legal regime leading up to abortion bans in the many U.S. states. I actually had not planned on really belaboring that. If you are very interested in it, you may go and read it for yourself. But suffice it to say, as a general matter, the law did not concern itself with termination of pregnancy until the 1800s. Medical practitioners of various quality, primarily women who were herbalists, were offering different sorts of medication to terminate pregnancy throughout every era of history, up to and including the 1700s. And this was judged with fairly little it was not judged harshly, as long as it took place prior to quickening, which is when you feel the baby kick. Basically, that's you can tell, which when you think about it, before you have medical technology, that's your first indication that you have a live fetus. is that it starts to move in the pregnant person's body. So the law is not concerning itself with this. If a person wants to seek out a medical practitioner to become unpregnant, that's their business. Some communities have moral concerns with out-of-wedlock pregnancies. I think most of us had to read the Scarlet Letter in high school. We're all familiar with how all of this worked. And so many people seek out that kind of treatment for reasons of community rejection in the alternative, or, people just like now, people find that they have too many children to support and do not want to be pregnant again and add to their families. Fine, whatever. 1821, we start getting the first U.S. state banning abortion. And there is kind of a cascade of states instituting those bans. By the time we get to Roe v. Wade, the state ban that is being challenged is a state ban in Texas. This is 1973 when it works its way up to the Supreme Court. So let's talk about the Supreme Court in the 70s and Roe specifically. The legal framework under which the Supreme Court is considering rights and what the Constitution actually guarantees to people is much more expansive than we see the Supreme Court of the 2000s, 2010s, and 2020s.
Yeah, this whole period is an expansion of rights that we find, and I can't remember which justice writes this, but that we find them in the penumbras of the Constitution. Yes. That there are certain rights which are necessary for other rights in the Constitution, right? But which are not explicitly stated in the Constitution. And so there's a series of decisions leading up to Roe that sort of, this is where you get the logic that we'll see in Roe comes out of things like Griswold v. Connecticut and stuff like that.
Exactly. Or in a completely different case, I think a very good example of this, because people are so familiar with it, is Miranda v. Arizona. So a completely different context. We're talking about criminal defense and what your rights are as a criminal defendant. The Miranda v. Arizona case is what gets us the quote unquote Miranda warning that you see in every police procedural TV show from then until the end of time, or until Miranda is undone. We'll see. You find the court saying it is not just enough that you have the right to remain silent. You have the right to an attorney. What is necessary to invoke those rights is to know that you have them. So in addition to having the rights, you have a right to be told. You have a right to remain silent. If you do not remain silent, anything you say can be used against you. You have a right to an attorney, and if you cannot afford an attorney, one will be appointed to you at no expense to you. That is not in the Constitution. Miranda warnings are not in the Constitution.
And specifically, the specific phrasing is definitely not in the Constitution at all.
There's a reason I can recite it from memory, you get a little, you can get a little extemporaneous to make sure people understand what you're saying. But that specific recitation of your rights as a criminal defendant, the Constitution doesn't say the police have to remind you. Of course, the Constitution was written at a time when institutionalized police forces didn't really exist.
Yeah.
So we see a kind of very expansionist view of what your rights are, and that people are considering, lawyers and judges and justices are considering what you have to have in order to have the rights that you do find in the text of the Constitution. So from that posture, we get the decision in Roe v. Wade. Roe v. Wade says that there is a right to abortion found in the right to privacy in the 14th Amendment Due Process Clause. So, this is a weird place to put it.
It is a little bit of a weird place to put it, especially when the Equal Protection Clause is sitting right there.
Like the next line. Yeah. Yes. And I think we're going to discuss a little bit about how that would have been better. Here, stick a pin in that. But it's really weird because when we say due process, and due process is a word that is flying around all over the place, right? Or a phrase, excuse me, it's 2 words. It's flying around all over the place. I'm going to hate myself if I listen back and go, like, due process isn't a word.
We could call it a term, right?
A term,
there are
a
2-word
phrase.
terms, yeah.
It is a 2-word term. But people are saying it like it's one word. Due process, due process, due process. Due process, we could just say process also. But we're all just talking about what processes do. That's not really the part of it that we care about for a privacy right to abortion. It's the part that says that no state shall deprive any person of life, liberty, or property without the due process of the law. That makes it sound like privacy is a component of process, which it is, but there's also a privacy interest that is necessary to have liberty. To be a free person, you need to be able to make decisions about the composition of your family and how you're going to raise your children and whether or not you're going to get married, that sort of thing. And so that's where we start to find, there's a privacy interest in the due process clause in Griswold versus Connecticut, which you just mentioned, which is a right to contraception. These are where you get rights to send your children to parochial or private school, which was outlawed in an anti-Catholic measure for a long time. That's where we sit those rights, in the right to liberty, in the right to due process.
And I do wonder sometimes whether if we hadn't gotten the specific couching of the right to contraception in privacy instead of in something like the right to contract that they'd created or like some other weird part of the Constitution, if they would have decided Roe in the same way. Because it sort of feels a little bit to me like learning about this in like history classes and like political development classes and stuff, that like, well, they already had Griswold, right? It was sort of sitting there, and they were like, well, let's just double down on that a little bit. People don't seem to have a huge problem with that.
Absolutely. And if you read the opinion, it's almost like you're yada-yadaing over that part. It's just like, well, obviously, because Griswold is there. Loving v. Virginia also talks about it. So, this marriage and family is here. And, again, we're going to talk about equal protection. And I think that makes more sense given how the law has evolved to protect pregnancy since then. So maybe, but it gets stuck in due process land, which is strange. But then you have the idea, even as early as Roe v. Wade, that it's not an absolute right and that the state does have some legitimate interests in restricting it. The state of Texas advances 3 different interests that it says are legitimate. Interest 1, which the court says is not a legitimate state interest, is discouraging promiscuity. So, according to the Supreme Court, the states cannot stop you from slutting it up.
You can be as randy as you want.
Yes, they can't stop you. But the two interests that the court does recognize as legitimate, interest number 1, that is legitimate, is protecting the health of pregnant people. In the first trimester, and this is when we get the trimesterly framework. In the first trimester, it is safer to get an abortion than childbirth. So the state can't intervene to protect people medically. Starting in the second trimester, the state can do that. Last interest that is legitimate is protecting the life of the fetus. That interest kicks in and becomes legitimate at the time the fetus would be viable, meaning could survive outside of the womb. In 1973, that was the third trimester. And I say 1973 very specifically because this is a moving target. And the fact that this was not thought of at the time strikes me as very interesting. The third trimester is, I didn't even do the math on this, but it's going to be something like 28 weeks.
Yeah.
Now viability has moved forward. The most recent information that I found is that at 24 weeks, you have a greater than 50% chance that a fetus will survive if it is delivered at 24 weeks. You can get as low as 22 weeks and have a fetus survive, obviously for 22, 24, we're talking massive medical intervention to make that happen. Additionally, this occurred to me this morning. I don't know that viability is the same in Fargo, North Dakota as in New York City. Just in terms of what you have access to medically. Do you have the best NICU in the world in Los Angeles and maybe just your average NICU in Fargo? NICU being neonatal intensive care unit. So something to think about. Is this actually something that is uniform across these 50 states and in every county in the country?
It's one of the several things that like makes the Roe decision not perfect, right? Even though it was like the bedrock of abortion rights for a long time, is that like justices on the Supreme Court are very, very good at one thing, and it is legal interpretation. And then they are not very good at most other things. Like there's an episode where like Justice Roberts basically referred to a bunch of like statistically based social science evidence about like how you could not get the kind of maps that Wisconsin had drawn without gerrymandering. And he was like, what is this sociological gobbledygook? Like, one, getting the field.
Are we denying the existence of math, sir?
Getting the field wrong, right? And then two, like not understanding how statistics and math works, right? Like,
okay.
So that's the sort of, that's like the level of expertise we're working with in a field that is even like adjacent to like legal reasoning, perhaps. Where we might think social sciences are more adjacent to the law than something like medical science or biology, right? Which they like just probably don't have any inkling of like exactly how these things work, right?
Perhaps not, no.
But so the Roe decision in 1973 is the controlling opinion for 19 years, if I'm right. And then we move on, and under this idea that there is a legitimate state interest still in regulating abortion, we get the decision that was actually the controlling opinion between it and Dobbs, which is Planned Parenthood v. Casey. So what's up with that?
So Planned Parenthood v. Casey changes the standard. So we had the trimesterly framework from Roe v. Wade, and we kind of get rid of that in Planned Parenthood v. Casey, which is a very interesting opinion in that 3 justices co-author the majority opinion. It was very contentious. It was very dramatic, as you would expect, because, side note, there's been all of this organizing among right-wing and especially evangelical conservatives who are mobilizing to try to get Roe v. Wade overturned. You also have a legal movement that is in many ways structured around undoing or presenting an oppositional interpretive framework to the penumbra idea, or that what do we need to make these rights work? What would the founders kind of think if they were here now? How do we need to adapt our society or our law to meet our society where it is now?
Yeah, this is what we've talked about before. This is originalism or textualism. It's the dominant legal framework on the right nowadays, but it really gets its start in the mid-20th century and gets supercharged after Roe v. Wade.
Yes, because you have this confluence of social conservatives and legal conservatives trying to figure out how to unite their power and use it in a branch that they can exert more control in. So you have this now Planned Parenthood v. Casey decision where you are not seeing this sort of penumbra right issue. They don't overturn they don't overturn Roe. They don't say there's not a right to abortion, but they change what the standard is. They say that the standard needs to be whether or not a regulation on abortion pre-viability will create an undue burden on the person seeking an abortion. And undue burden, they explain, as basically, does it present a substantial obstacle to seeking an abortion? It's
one of the wishier, washier legal tests that the Supreme Court has come up with.
And then to give you, it's not just what they say the words are. I mean, words mean things. But then they have 3 examples because the Pennsylvania law being challenged gives you 3 things to argue about they have the three examples and they get to tell us these two are not an undue burden, but this one is. So the three things that are challenged are a 24-hour waiting period. So you go in for a consultation and then you have to go home and wait 24 hours and then you can go get your abortion. The parental consent for minors provision, at least one parent has to sign off, and there is a court workaround where a judge can authorize it. And the third is a married woman must get her husband's consent to have an abortion. The 24-hour waiting period and the minor parental notification provision are not undue burdens on the person seeking an abortion. The spousal consent is, according to the Supreme Court.
Which, again, just feels maybe a little bit like, okay, why? Right? Like, but it's what we're left with, right? And so, as a result of this, perhaps like pretty wishy-washy test, not extraordinarily clear exactly what it should mean, not clear how you adapt those three examples to all sorts of legal trickery. What follows is you get literally 30 years of legal trickery from states that want to try to ban abortion, trying to get around this undue burden standard by doing things that like aren't directly targeting abortion, but are absolutely targeting abortion.
Yes, exactly. You see a lot of targeted restrictions on abortion providers, often called commonly called trap laws. These are targeted at abortion providers like Whole Woman's Health of Jackson, Mississippi, making it harder for them to stay in business effectively, making it more expensive, making it more difficult for them to operate. They're not saying that women can't get abortions per se, which is how you kind of get to well, it's not an undue burden. They could just go someplace else. Not if the only provider in the state and every surrounding state is no longer providing abortions, but okay.
Yeah, and when we talk about these like targeted laws, like an example, I'm not sure if it was Whole Woman's Health itself, but it was one of these abortion clinics in the South. A state basically passed a bunch of laws that abortion clinics had to have like the same operating structure the same architecture as like hospitals, right?
Yeah, width. They're regulating the width of the hallway.
And then also all of the doctors at these abortion clinics had to have admitting privileges at the nearest hospital, right? And that was something that like the nearest hospital to Whole Woman's Health, which I believe was a Catholic hospital, was not going to allow. Like they're a Catholic hospital. They don't have to allow an abortion doctor to have admitting privileges at their hospital, right? And so there's like, they had to move where the clinic was. And like, I think the story, I remember seeing this was that like he invested like the doctor that runs that clinic or the person who was at the head of it invested something like $3 million in making sure that the clinic was fully compliant with all Mississippi state law. And then they just did more stuff, right? That like, yeah.
You wind up in a situation where between the compliance with the regulations always changing, and then you are constantly in litigation, it has the effect of draining the resources of providers without even actually providing any care.
Because if you need to spend $3 million just to be legally allowed to operate, you have a lot less operating budget left after that. Yeah, it just... and we saw this not just in Mississippi, obviously, right? But like in a bunch of different places, basically. States all around the country with Republican-controlled legislatures and governorships and all that, they pass these sorts of laws all over the place.
Yep. So they're doing what they can, these Republican state legislatures, to limit abortion without actually running into that undue burden standard. And then the Mississippi state legislature decided that it was just going to run straight for the buzzsaw and see what happened. In March 2018, Mississippi legislature passes the Gestational Age Act, which banned any abortion operation after 15 weeks. As we have said, viability is still in the 20s, 22 to 24 weeks.
It's like
15 weeks.
Yeah, 2-ish months, like from that time. Yeah, absolutely.
Mm-hmm, mm-hmm. So they're way ahead of viability, which if you're taking Planned Parenthood v. Casey as the standard, saying you can't have an abortion prior to viability, that's an undue burden. Just definitionally. So they are saying at this point, the Mississippi State Legislature is saying, if you want to uphold our law, there's really no way to finesse this. If you want to uphold our law, you need to say that Planned Parenthood and Roe were wrongly decided. Basically.
Yeah. They don't leave any wiggle room, right?
Yeah.
I suppose they left some room in that the Supreme Court could have decided that the standard should live in something like equal protection. But realistically, that was never going to happen.
No. And this is mid Trump's tenure. You can look at the composition of the Supreme Court and do some math.
Yeah.
And so the Mississippi law, the Gestational Age Act, did have exceptions for medical emergency or fetal abnormality, but none for rape or incest. So common kind of exception framework in these laws. You can have exceptions for the health or life of the pregnant person who is carrying the fetus. You can have fetal abnormalities that are going to be incompatible with life once the child is born. So you may want to terminate if, for example, the fetus's skull has not formed, is a fetal abnormality that happens. You may want to terminate because that fetus, when it is born, will not survive. So also rape or incest, if the pregnancy is a result of rape or incest, you can have an exception saying that termination is permissible under those circumstances. Those are the common exceptions in these abortion ban laws. Just quick note. So it has some of those, it does not have others. The majority opinion in this case, in Dobbs, written by Alito, which honestly, I'm not going to go into the leaking of the opinion too much, but you knew.
Yeah.
Anyway, the majority opinion says, effectively, there is no right to abortion in the Constitution. There is no right to abortion in the Due Process Clause. It was improper for Roe v. Wade to find it in the Due Process Clause because, according to them, that provision, the Due Process Clause of the 14th Amendment, has been held to guarantee some rights that are not mentioned in the Constitution, but only rights that are deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty.
Which is, to me, a completely meaningless phrase. Like, it's just actually fancy sounding word salad.
For a group of people that can't understand sociology to crown themselves the nation's leading historians.
Yeah.
Seems like a choice.
Like saying something deeply rooted in the nation's history and traditions is actually meaningless. Like slavery is deeply rooted in the nation's history and tradition. Is there a right to own slaves in the right to property that is protected by due process? It literally only means whatever the justices on the Supreme Court decide it means at that time. Like that is all it means. That's all it can be taken to mean.
Yep.
It's very aggravating.
Yep. So anyway, there's nothing to say about that really, honestly, that hasn't been said by a million other people.
Yeah.
And so it's a bad test. It is a vague test. And as I will discuss as we progress through my notes here, vagueness is the enemy. So let's talk about post-Dobbs. This happens, states go hog wild because all of a sudden Republican state legislatures can pass abortion restrictions, whereas they couldn't before, which is fascinating. They have no backstop on this anymore. No minimum protections for people who are or can become pregnant other than their voters. And these state legislators kind of come face to face with exactly how precarious their coalition is on this particular issue. They have a kind of dog caught the car situation where they have a group of people who are primarily focused on eliminating abortion completely. All abortion is murder. Doesn't matter if you were raped by your stepfather and got pregnant or what have you. If you are terminating your pregnancy, you are committing murder, period. You have those folks. And you have folks who kind of have a sense of understanding of when an abortion might be medically necessary, might be preferable, who think a teenager raped by her stepfather should be able to terminate a pregnancy because that's a terrible situation and you want her to be able to move on with her life, etc. Those people have directly oppositional views. Both are voting Republican, and Republicans feel as though they are beholden to both. They have to thread that needle, and that is very difficult for those folks.
The abortion laws that they end up passing as a result are, shall we say, poorly designed.
Yes.
And we can talk maybe a little bit more about the exact consequences of those being poorly designed in the back half, I think.
Absolutely. Absolutely. If you want to talk a bit more, I have quite a bit about what happens when you have a very vaguely written law, and we can absolutely push that to the back half. But suffice it to say, when these laws have poorly considered exceptions for the life or health of the mother in particular, you create an incentive structure where a hospital will err on the side of not providing abortion care, and that puts the health and life of mothers repeatedly in jeopardy. And we see that over and over and over and over again.
Yeah. I think perhaps before we take a break, maybe let's just go over a little bit of like, given the legal framework that we're dealing with now, right? Given the fact that we've talked about how Roe and Planned Parenthood v. Casey were actually sort of weird precedents to begin with, like what would the legal framework that you would like to quote unquote return us to, like return us to having abortion rights, but maybe with a new legal justification? What would your ideal scenario be in that for that case?
Well, I have a couple. My ideal scenario would actually be a constitutional amendment creating a right to privacy, quite frankly. Returning us to our episode on just change the damn constitution, stop finessing extra stuff into it. But if we can't do that, I would say that there is a strong argument to be made that the right to an abortion or medical intervention specific to one set of reproductive organs over another, that needs to be in the Equal Protection Clause. And there is so much now subsequent to this. You kind of get a legal evolution where the ability to get pregnant is true for a subset of humans. Not all women can get pregnant, but you have a kind of correspondence between women and people who can get pregnant. And so for the law to equally protect women, it needs to protect pregnant people and to protect them during their pregnancy or protect them when it is possible for them to become pregnant. So I would say situating the right to an abortion in the Equal Protection Clause of the 14th Amendment ensures that the law is not treating women differently because they can become pregnant.
Yeah,
so
and I
that's
think
one thing I would like.
I think that, like, as you mentioned, the like legal framework there has like really developed since Roe v. Wade, where we now have much more of a legal like jurisprudence surrounding the idea that like sex is a protected category, like gender orientation is a protected category. There you cannot be discriminated against because you are pregnant, right? Like you cannot be fired because you are pregnant, right? Like there's legal frameworks around like you have to be at least given like job security after you give birth, right? And certain states go farther than that, right?
And you can't be fired for being pregnant. Yes, exactly.
Yeah. And so it makes more sense, I think, given that developed jurisprudence that we make the argument that basically says, like, in order for people who are able to become pregnant to be able to have the equal protection of the law, to like live as equal citizens, they need to be able to have control over their own reproductive choices. And that's just, it is necessary for the equal protection clause to exist, that this be possible for people who can get pregnant in the United States.
Absolutely. Somewhere else you might want to situate it, and this is my favorite creative argument that I have seen around this whole concept. It is an issue of religious liberty that particularly Jewish families be allowed to terminate a pregnancy if it is going to result in harm to the person who is carrying the fetus. Life begins at birth in Judaism. I think it is life begins when the fetus is 3/4 of the way out of its mother. And so we're imposing, quite frankly, a Christian value on non-Christians. And in this country, we're kind of not supposed to do that. So even as someone who was brought up largely Catholic, this isn't something that should be imposed as a Catholic value. This is not something that should be imposed on other people. And certainly not while we still have the death penalty too. Like, just consistency. Anyway, so I would submit to you that there are people who just do not adhere, even atheists. There is no mention, I think, of abortion in the Quran. Just, we are imposing Christian values on people who are not Christians, and that is a violation of their religious liberties or their liberty to not have any religion at all. So there's another place you could put it if you were so inclined. There is a case in Kentucky working its way through the system where 3 Jewish plaintiffs are arguing that this is an imposition on them and their religious freedom. Additionally, another alternative is state Supreme Court amendment or state constitutional amendments that protect privacy. 11 states have privacy rights in their state constitutions, and Wyoming, bless their hearts, has a right to medical decision making in their state constitution because of the Obamacare death penalties that they were afraid of.
Yeah.
So
yeah,
go team.
They accidentally passed a right to an abortion into their constitution. Yeah, and then
that's what an unholy alliance could be formed between anti-vaxxers and abortion advocates on this one.
And then there are also a number of states that have explicitly put just a right to an abortion in the state constitution.
Yeah, I think Kansas. That was the thing in Kansas. Yeah,
yeah, and
so
also
there
California
did
it by ballot initiative. Yeah, California did it by ballot initiative in 2022. A few other states have done so.
Yeah, you can be that specific. You can just do things. So those are some legal options or ways that we could change the legal framework to protect abortion rights. But we can also talk about how to make these bad laws slightly better. But I think, as you mentioned, we will do that in the back half when we talk about policy.
Yeah. And with that in mind, let's take a bit of a break. We'll come right back. We'll talk about the consequences of these abortion laws, both ill-designed and even a tiny bit better designed, and why, just from a pure policy standpoint, we should be rejecting these kinds of laws. Hello again, everyone, and welcome back to Reject Modernity, Embrace Tradition. When we left you, we just finished going through all of the sort of legal ramifications of the abortion sort of sphere in American life. And now we're going to go through some policy consequences. Talk a little bit more concretely, perhaps, about what it is these laws actually end up doing when they get implemented. We're going to do sort of the empirics first of like what actually happens, the studies that have been done, the broad impacts of these laws. And then Megan's going to take us through sort of a particular case study to see like if states just cannot be fucked to like leave people alone, right? If they cannot be persuaded that the consequences of these abortion laws are bad, there are ways that at least maybe they should design them to result in fewer people ending up dead. Which is probably, Not the ideal, but at least a little bit of harm reduction. So without further ado on that, let's go ahead. Let's talk about some of these policy consequences. So one broad detail I want to note here before we begin, though, is that the United States is, in fact, a global outlier nowadays in not protecting reproductive freedom. According to the World Health Organization, nearly 60% of the global population lives in a country where abortion is, broadly speaking, legal. There are different, regimes as to exactly when it becomes legal, exactly when it becomes illegal, so on and so forth. But the United States is actually a global aberration in this respect, in that there is no federal, national level protections for abortion anymore. And the primary consequences of the abortion bans that have been passed in various states, with the lack of protection involved, is just to make it more dangerous for women to access reproductive care. That is the primary thing that it actually does. You might think to yourself, you might say, well, actually, the primary consequences should be that women just have more babies and fewer abortions. But nope, actually, in fact, that's not the primary consequence. These bans absolutely reduce the rate of safe, legal abortions, but that is not, in fact, the only type of abortion that is out there. And the primary effect of these abortion bans is just to push women towards more dangerous abortions, more dangerous reproductive care in, unlicensed areas, in poor facilities, so on and so forth.
Where you're taking medication or herbal supplements unsupervised.
Yeah, you're trying to. You're self-inducing abortion, right? Just to provide a little bit of context here, a 2020 research article in The Lancet, which is one of the world's most respected and highest impact medical journals, finds that even in areas where abortion care is restricted, women still regularly seek out that care at basically the same rate as women who are living in areas that have safe and legal abortion available to them. So women are seeking abortions at the same rate. It's just the kind of abortion that they are seeking that has changed. And this has really disastrous consequences. A 2012 study in the Journal of Obstetrics and Gynecology finds that safe abortions actually have a mortality rate several times lower than childbirth. But a 2015 study in BGOG finds that unsafe abortions have a mortality rate that is 23 times higher than childbirth, and more than 200 times higher than safe abortions. The rate is less than one. The fatality rate is less than 1 per 100,000 for safe abortions, and more than 200 per 100,000 for unsafe abortions. It's like 2 orders of magnitude difference in the level of fatality. So in essence, the main thing that you are achieving when you pass these abortion bans is you just end up killing women. That's the direct impact. That is what's happening. Any actual reduction in the amount of abortion that you achieve is mostly incidental, and it is at the expense of many thousands of additional deaths from women, which is not, I would say, a particularly good trade-off if you're concerned about being pro-life, to be perfectly frank with you about it.
Those fetuses still didn't make it either in all of those dead mothers.
Yeah, exactly, right?
Not to be crass and blunt about it, but it's not actually reducing.
But to be a little bit crass and blunt about it, right? Quite frankly, anyone who's ever experienced these protesters, right? Outside of an abortion clinic, or who's ever had to have them come to your high school, right? Or your college campus. They're fucking assholes, right? So I don't care about being a little bit blunt or crass or anything, right? They deserve to be told that what they're doing, they deserve to be told the truth. What they are doing.
This is dumb and wrong.
Yes,
dumb, bad, and wrong.
Dumb, bad, and wrong, and what they end up doing is just killing women. That is what's happening. That is the end result of their actions, whether or not they think it is true. But that's not where the negative health impacts stop here, because there are also a lot of other like health outcomes that are worsened by curtailing abortion care. But specifically, this is because lots of abortion providers, both in the United States and outside of the United States, like Planned Parenthood, for instance, very well known for this, also provide a large range of other health services, right? Specifically women's health services. And those services are at risk when those clinics are targeted by anti-abortion laws. Both the trap laws we talked about earlier in the pre-Dobbs era and like the outright abortion bans that happen nowadays. And this threat to these other forms of reproductive care result in higher rates of other kinds of pregnancy complications for women who actually intend to carry a pregnancy to term and actually have the child, as well as delayed detection and treatment of many cancers, STDs, and lots of other conditions that primarily impact women. The upshot basically being that not only are you resulting in lots of women dying from unsafe abortions, you're also resulting in more women dying from other health concerns that prior to this legal regime, they largely would have had covered or detected or treated by the same kind of healthcare infrastructure that these laws target, which is, again, not a particularly pro-life thing. Which is why I think it's a good way that people have taken to describing like this whole pro-life anti-abortion advocates as being pro-birth rather than like pro-life or any sort of thing. Because they just don't care. They just don't care about anything that happens after the baby is actually born.
Yeah, or we would see that there is some sort of legal regime or change around, you know, any of the things that are incentivizing people to seek abortion in the first place. But, you know, here we are.
Yeah. Here we are indeed, unfortunately.
Yeah.
Sorry, go ahead, Megan.
Go ahead.
I was going to say, additionally, all of the stuff that we've talked about in the last, nearly 10 minutes now of going through these policy outcomes, these consequences don't impact women all equally. They don't impact women in a fundamentally equal way. There's large disparities across race and across class. To put it bluntly, like lack of abortion access threatens women's health disparities along basically every single racial and economic line that we have. According to researchers at Johns Hopkins University, Black women are 3 times as likely, and Hispanic women are twice as likely to seek abortions as white women are. And while women living below the poverty line is only 11.1% of the total United States population, half of all women who seek abortion care are below the poverty line. So essentially, unplanned pregnancies and births already hit lower income and women of color more heavily than they hit higher income women and white women. Lack of access to abortion care only makes those disparities worse. Because in addition to the pre-birth impacts, we also have post-birth impacts that are disparate across racial and economic lines. Unplanned pregnancies and births among women of color and among poorer women are more likely to result in the mother being left alone to raise the child because the father is a deadbeat who can't be bothered to stick around and finish what he started, basically. They're more likely to remain in poverty or to have lowered income because of different labor market outcomes, right? It's harder to work sort of an hourly job than it is a salaried job, right? If you have a young child and you have to be on call and you have to come in at various times. So it's harder to sort of make any sort of progress in your career. And then I think probably maybe worst of all of these, quite frankly, is that women who have unplanned pregnancies, unplanned births, particularly lower income women and women of color, are more likely to experience intimate partner violence than higher income women and white women are. And so in every single way, basically, related to childbirth, child rearing, and health, and many economic outcomes, lacking access to reproductive care hits poor and non-white women substantially worse than it hits higher income women and white women who are.
And of course, let's not forget that it's more dangerous for women of color to be pregnant in the first place. Maternal mortality is dramatically worse.
Much higher. Yes. So yeah, it's much more dangerous for women to face pregnancy complications in the first place, right? Yeah, it's a whole deal. And I guess the long story short is what we have here is basically mostly a bunch of white women, mostly sort of middle class and upper class white women, fighting to restrict abortion rights, who will then not be the ones who have to face the brunt of the consequences of that decision making. Which, on top of everything else, is just like one added little cherry on top of this like shit sandwich that anti-abortion policies, bring to states that adopt them. It's bad. It's bad. It's just bad.
It's just bad. It's just bad. We don't have anything good or optimistic to say about that.
No.
And even in situations where legislators who are trying to restrict abortion but are trying to kind of do the right thing and look out for women, they often wind up not doing that and still putting women in danger. All abortion bans have the effect of putting women in danger. Or another pregnant person who does not identify as female, to be inclusive. But the thing that I really want to talk about here is the fact that vagueness, as I mentioned before, is really the enemy. And when you have a law that is purporting to say that if the life or health of the mother is at risk, then an abortion is permitted, there's not a really good way to write that.
Yeah, you got to be clear about what it means for the life or health of the mother to be at risk, or at the very least, you have to say if her doctor determines, or if their doctor determines that the life or health of this pregnant person is at risk, then they can use their best judgment, and we will not prosecute them for it, right?
A literal get out of jail free card is what is needed here. Well, and so just to, I do want to take you through an example
of course,
a maternal mortality that occurred even in a situation where arguably the abortion would have been permitted under the law. This is a massively famous case in Ireland from 2012. It is the case of Savita Halappavanar. She was 17 weeks pregnant when she went to the emergency room, well before viability, both in 2012 and now. Not that is important under Irish law then or now, but it is important to us here in how our previous legal framework was structured. So she went to the emergency room. She had to go to the emergency room twice. First for lower back pain, and next because she felt like something was coming out, quote unquote. The gestational sac, so the little bubble of amniotic fluid that the fetus was in, was protruding from her cervix. And it was determined that a miscarriage was inevitable, but the fetus still had a heartbeat. And under Irish law, these two things were simultaneously true. Performing an abortion was punishable by up to lifetime imprisonment, and abortions were allowed in cases where the life of the mother was at risk. The latter point was determined by an Irish Supreme Court case, the X case, because the mother was anonymized in that case, I believe. And that's from 1992. And it had not been codified, so you don't have an explanation or a definition of what the life of the mother could be or would be. If there's a list of potential complications or consequences, what does that look like? It's just a kind of generalized concept of the life of the mother. And then the law making abortion punishable by life in prison was a British law that was a holdover from the 1800s.
Hate it when that happens.
Yeah, dang it. Imperialism. So both were binding on the hospital. On her second day in the hospital, her water did break. This is important to note because as anyone who has ever had a baby or had someone close to them have a baby, you know the longer you go between water breaking and birth, the greater the chance of infection. This actually happened to my best friend when she had her baby last year. Like 4 days went by and she did wind up having an infection and needing antibiotics, even now in 2024. This is a completely normal thing because you've got your body hanging open and you can get germs in there. So Savita discussed abortion with her doctors, but her request for an abortion was denied as illegal. She completed her miscarriage sometime between her 2nd and 4th day in the hospital. She was diagnosed with sepsis on the 4th day, and on the 7th day, after seeking treatment, she died. She died of sepsis. She died of organ failure. So, inadequacy in the medical care has been identified in this case as a complicating factor. If the staff had appropriately diagnosed sepsis, it would have been lawful to facilitate the miscarriage with a dilation and curettage, a D&C. But if the law relies on accurate diagnosis and the ability of a hospital's legal team to fit that diagnosis into a pre-existing legal exception, you are creating opportunities for failure and death.
And this has happened. This has happened a number of times in the United States since the Dobbs decision.
Yes.
I don't know how many of them. How many? I'm not sure off the top of my head how many, if any, have actually resulted in death. But several times, women have gone to hospitals in states that have abortion bans. They've been in the process of having a miscarriage, and the hospital has refused to perform a medical abortion procedure that would help complete the miscarriage.
Your death is not sufficiently imminent.
Yes, yeah,
more or less is kind of the issue, and that's why we're talking about this, because if you have just when the life of the mother is at risk in your law, what does that mean? And even if you have a list of reasons why the life of the mother may be at risk, you are inevitably going to miss something. And then your legal team at the hospital is in charge of determining, the hospital's lawyers, where the patient is not the client, the hospital and its doctors and nurses and staff are. They are responsible for determining whether or not that abortion would fit within the law or could get their employees prosecuted.
And notably, go ahead.
That incentive structure creates one where you are going to, as the lawyer for the hospital, err on the side of not giving an abortion.
And also importantly, again, the lawyers for the hospital, not medical experts, right? Like, in the same way that the members of the Supreme Court are not experts on things that are not the law, the lawyers for the hospital are not experts in what might end up becoming a life-threatening situation for the mother at the hospital seeking abortion care because she's in the middle of a miscarriage. Like, they're not experts. They're simply not. And, I know that sort of we've, it gets bandied about, it gets joked about a little bit, but practicing medicine through law is, and again, I am not a lawyer, I am not a doctor, I am also not an expert in these things, but it strikes me, quite frankly, as very much practicing medicine without a license.
Yeah. As a person who is a professional and takes great pride in doing my chosen profession well, I would be extraordinarily frustrated to be in a situation where I have an oath versus the law, and those two things are running into each other. That would be, I can't put myself in the shoes of a doctor who's being told by hospital attorneys that they can't perform life-saving medical care. I cannot imagine how that feels. But again, anytime you're getting the hospital lawyers involved, you're also taking time. And as we just mentioned, the longer someone is laboring with an inevitable miscarriage, the higher likelihood of some sort of complication being developed. So that time is also creating risk. But where I'm headed with this essentially is that writing laws is hard. That is what I do professionally. It is difficult, and sometimes you have a concept that just won't write in a way that does what you need it to do and is sufficiently thoughtful of the potential negative consequences. Even if what you want to do is to limit abortions, but provide that safeguarding of maternal life, you have to write that in a careful and thoughtful way that is mindful of the incentive structure that you are creating. So I have a suggestion for how to do this not quite so badly. Would you like to hear it, Clayton?
I'd like to hear it.
Okay, if you absolutely positively have to write an abortion ban, but it is going to include provisions safeguarding the life and health of the mother, I would strongly recommend to disincentivize hospitals from erring on the side of not giving abortions, even when the law would permit them to, because they feel it is the safer choice for them and their staffs, to say something comparable cutting the other direction, such as proposed language, don't come for me, something like providing an abortion may be punishable by yada, 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 whatever your punishment is in your legal framework, except in cases where continuing the pregnancy will lead to the imminent death of the mother. That imminency needs to be defined. You need to have a situation where you are also saying, at the same time, failure to provide a medically indicated abortion is also punishable by XYZ and subject to civil penalties.
Yeah, I think this helps with the incentive structure at least, right?
Yes.
Like, obviously, the preferred legal framework is leave everyone the fuck alone. And
yes.
Like,
obviously. But if we are taking as a sunk cost that
Yes.
South Carolina is going to try to ban abortion, then what you need is a legal structure where you are matching the providing an abortion may be punishable by up to XYZ with, and not providing an abortion may be punishable by XYZ if exceptions are not honored at the request of the pregnant person or whatever.
Yeah.
You have to be meeting it on the other side, or even in a situation where, I keep blaming the hospital attorneys. The hospital attorneys have clients that they're trying to protect. That is literally their jobs. So they're trying to keep providing care for other people down the road. They need to have that incentive structure created for them in such a way that they are erring on the side of caution by providing the requested medical care to the person who is asking for it.
Yeah, and I think also part of this could be writing into the law that when the life or health of the mother exception is being called upon or whatever, the courts will give precedence or preference to the opinion of the attending medical professional.
You want Chevron deference for the physician who is actually attending the pregnant person.
Yeah, basically, right? If
qualified immunity for the doctor in the case or something.
If some prosecutor in Texas decides that he's going to go off on a spree of trying to, prosecute a bunch of physicians at emergency rooms that did abortion procedures for women who are having miscarriages, the law should give preference to their medical judgment in the moment, not people who had 3 months to look over the case and decide, with this panel of, hired medical experts, whether with the benefit of hindsight, because again, we have discussed time is of the essence here, right?
Yeah.
With the benefit of all of this data and all of this time and as much time as you could possibly need to gauge whether or not this was actually medically necessary at the moment that it was done, you should give deference to the medical professional who was the one in the room making the decisions, trying to save this woman's life. That probably goes too far for these conservative states that are going to pass abortion bans, but whatever. If they're
it's a negotiating position, if nothing else.
If we're living in a fantasy land where we can ask these, if we're living in a fantasy land where we can ask these states to make slightly less bad laws, then
We're honestly, we're talking to Republican legislators in many of these situations. Like, you have a situation where it was female Republican legislators in South Carolina. I believe it was 3 Republican state senators, all of whom were women, who were the ones who blocked an abortion ban in South Carolina. They said, we're not going to vote for this. So in many situations, you are negotiating with the person in power who is a Republican, but you're saying, we understand, we hear what you're trying to do.
We know you're going to ban abortion. We're not going to convince you not to.
Yes, but here's a way to do it that is less harmful to women. And I genuinely believe, even if I may not, I genuinely believe that you aren't looking to gratuitously harm women. Here's how to do it as safely as possible. You know, again, like we're arguing with the tools that we have here.
Mm-hmm.
We're not wish casting, leaving everyone the fuck alone. It's not gonna happen. But we can try to finesse a less bad solution. I think you mentioned harm reduction earlier.
Yes, we can try to reduce the harm that these laws are going to do while the legal framework allows them to be put in place, while we organize on the back end of all of that to get a new legal framework in place.
Yes.
That once again,
multi-pronged attack, Clayton.
Once again makes it impossible for states and state legislatures and Republicans, even in the national legislature, perhaps, to pass these laws that end up being bad for women. I will say, I'm not totally sure about some of these people. I think maybe they do actually intend to harm women, because I think some of them are actually a little evil. But, you know, we'll not name any names. We'll leave it there. We'll just say that some of these people in government are not amazing human beings, and just leave it at that.
Spousal notification for an abortion. What's that about, man?
Questionable.
Anyway.
Questionable at the very least. But anyway,
hey, at least the Supreme Court figured out, like, that was not a good idea. What possible bad thing could result from this?
Yeah, I wonder if we talked about intimate partner violence earlier. That was so interesting. Anyway, we're getting a little bit loopy here at the end of the episode.
Yeah.
I think it's probably because this is just such a fun topic with nothing heavy at all. Anyway, long story short, everything is bad, quite frankly. The Dobbs decision is bad. The legal framework that it has engendered is bad. The consequences of the policies that it has allowed are bad. This is not our normal message of hope that we have at an end of an episode.
Last time we ended an episode hopefully.
I end episodes hopefully all the time, Megan. I'm like, here are all the great things we can do.
Okay. I think it's been a while. We've been on a streak.
Okay, yeah, actually we have. You're right. Anyway. Maybe, okay,
anyway.
You know how I'll end the episode this time around? Until we have something optimistic to talk to you about. I have been Clayton Becker.
I have been Megan Cox.
And we will see you on the next one.